But just to ask people to mute their microphones if they're not asking a question, just so we can keep the audio interference down to a minimum. I think probably what I'll do is rush through the slides and then try to make some time for questions at the end. Largely because I can only see the slides, so I can't see if people are typing questions in. But if people have got queries as they go through, type them into the chat, and I'll do my best to come back to those at the end or answer them in the chat by text afterwards. So welcome to all those who've just joined. I'll start shortly, but good afternoon and thanks for joining me today. And I guess just some thanks before I start. So thanks to Chartered Trading Standards Institute for the opportunity to speak about the Competition and Markets Authority's work on COVID-19. But also thanks to all of you for joining. It's good that we've been able to meet up, even if it's only virtually. And thanks also to all of you in the awesome community for all your hard work and your assistance in dealing with all of the many issues, some of which we'll touch on as we go through the presentation. In case anyone doesn't know me, my name's Andrew Hadley. I'm an Assistant Director in the Policy and International team at the Competition and Markets Authority. Worked on consumer law for most of my career back to 2003, but have been quite involved with the COVID work. So I'll start now, and please save your questions for the end. I've got quite a lot to get through. So what I'm going to cover today, I'm just going to talk a little bit about what happened at the start, if we can think back several months to the start of the pandemic. Very briefly touch on the sort of key legal principles in the Consumer Rights Act, Consumer Protection from Unfair Trading Regulations, and some other bits of law, but I won't dwell on that. Many of you have heard me talking about that lots of times before. I will then focus a bit on our statements on cancellations in particular, and then look in a bit more detail at some of the enforcement work we took before hopefully leaving some time for questions at the end. As I said before, kind of apologies, I'll have to rush through quite a lot of this because I think I need to move at about a slide a minute. So obviously lots of risks emerged at the start of the pandemic, but it wasn't really clear exactly what the consequences are going to be or what the CMA could best do in that area. And I think the really interesting decision that we took very early on was to be, as best we could, be guided by complaints, data and intelligence in kind of deciding where we would put our resources, because obviously there was a lot of demand from consumers, from businesses, also from yourselves in trading standards for us to deal with all of the different issues. So this is kind of what we were reflecting on quite early on. So obviously a lot of travel was suspended. Lockdown meant that a lot of economic activity was suspended or halted entirely. Lots of supply chain impacts, especially initially, and obviously impacts on lots of contracts, which is what a lot of the rest of the presentation will concentrate on. And as most of you will know, probably had personal experiences of this as well, tourism was hit especially badly due to those travel restrictions and uncertainty and people's fears about what might happen. Some of the initial consumer reactions included stockpiling. If you remember back when we couldn't get hold of any toilet paper, people kind of cancelling or changing their plans, making more use of e-commerce. Obviously, a lot of e-commerce shares have increased substantially in value as people are less able or less willing to go to shops, and use of online content. And also, and I guess this was particularly prevalent at the start, anger at some of the perceived price gouging practices and increased prices. So initially, this is what we did in early April, as it became apparent how serious the crisis was going to be. We set up an inbox for intel gathering, and that was then moved to an online form, and many of you have sent information via that or encouraged consumers to complain via that, and that has been incredibly valuable in guiding us to the right areas. And although obviously we have got quite a lot of people, quite a lot of resource, it's still finite, and we have a lot of other existing tasks to work on as well as this. We also decided to set up a dedicated inbox for trading standards officers and enforcers at the start, in case people had kind of urgent queries, and we got some very interesting comments and queries from some of you around that. We're doing less in that space now because we think things are slightly less urgent, but that has led to some sort of interesting thinking about how we ought to best communicate with yourselves in particular, kind of going forward. But we personally found that very helpful in the kind of opening weeks, when it really wasn't clear whether, you know, we were going to have to deal with kind of food shortages in particular areas, for example, because the pricing and the supply chains were so disrupted. We did quite a lot of internal work to get our own legal position on initially kind of the price gouging issues, and then increasingly on the unfair terms and other potentially illegal aspects of cancellation policies. We sent some warning letters. I'll talk in a bit more detail about that in relation to particular sectors. Obviously, lots of close working with yourselves, obviously also with the Civil Aviation Authority, Office of Rail and Road, and others. I'll talk a bit more about that later, and lots of conversations, especially in the early days, about potential legislation, particularly on price gouging, which didn't emerge in the end, although there are still some discussions about that going forward. So I won't go through all this in detail, but I mean, basically the point is that intelligence came in various forms. On the left was then prioritized through a large working group, and then kind of fed into different teams dealing with different areas. And then there were sort of various different actions taken by those groups. And then obviously increasingly kind of more press interactions and more press queries as well. But yeah, most of this is kind of internal CMA thinking. But just to sort of, I guess, yeah, the key point here is we were working out where we were going to park a lot of those complaints and how we could best deal with them. What we originally did was set some complaint thresholds, so that if there was a certain number of complaints about a particular firm, that would automatically trigger some more detailed casework, as it became clear that we couldn't deal with every single complaint, because there were literally at one point thousands or tens of thousands coming in at any given time. Yeah. So I won't go into a lot of detail about these, partly because they're not actually my slides. I've borrowed them from a colleague, but just to give you a sense of the sort of types of complaints we were getting and the sort of profile. So we had a big increase after we promoted some of our work in early May. Obviously, publicity drove a lot of interest in that complaints form, and that gave us more information to deal with. I think this is probably the most important slide in this section. So you can see here that initially, in the first few days at the end of March, the complaints were nearly all about price gouging. And then cancellation and refunds gradually eclipsed pricing and misleading health claims, which was the other sort of growth area. And then by the time we got to April, it was pretty clear that cancellations is going to be the main focus for us, and obviously that meant that it was going to be largely the consumer law and consumer enforcement powers of the CMA that were going to be needed to deal with some of these issues. Within that, we found that initially holidays dominated, and then over time we kind of found that flights, there was a big spike at the end of April in relation to that, but you can see, like, you know, between holidays and airlines, travel's been a pretty large part of our focus here, though not the only focus, which I'll come back to. And then just in terms of where our price gouging complaints were, that was initially very much focused on food and drink, interestingly, but then that was overtaken by hygiene and personal care, and some of that was tests, availability of COVID tests. Some of it was face masks, but I think the vast majority of that hygiene and personal care complaint area was hand sanitizer. And I'll come back to what we did with that as we move through. Just to give you a sense of where the complaints were. So this is up until the end of the summer. I think it's not the most recent figures, but you can see hand sanitizer and painkillers started to dominate over some of the food items and toilet paper. That was a problem in terms of price increases at the start. There's a whole lot more information about that if you're interested in the profile of complaints, when things happened, complaints within sectors at time. Please see those published updates. I can answer some sort of basic questions on that, but if you want to look at the detail, then please do have a look at those links. And then this is a kind of collection of all of the advice and guidance that we've published, a whole lot of news items. So if you're interested in particular areas, obviously I won't be only talking in a small amount of detail on some of these areas, but if you want to look at specifically what we said on holiday cottage refunds, for example, then have a look at the link, the relevant link. So just to talk in a bit more detail about really our mainly our consumer work. And I mean, I think one of the most interesting things about the focus of the problems, and particularly that interest in travel, was that created some pretty substantial overlaps with other enforcers, and that raised some sort of unresolved landscape issues. So we had a lot of contact with some of the trading standards regions and with CTSI early on in relation to price gouging, when that seemed to be the kind of leading issue, and that involved, you know, getting different intelligence reports from some regions, working out how we could best there and avoid kind of duplication. Very useful, and thank you to all of those of you who worked with us on that, and apologies if you didn't get back stuff as quickly as you would have liked from us, or you know, you're still waiting to hear back from us. I hope not. We then also had some incredibly useful conversations with CTSI about, well, what legal powers are there to address price gouging? You know, can we use the price indications legislation? Can we use the consumer protection from fair trading regulations? And that was really helpful, and we really appreciate everybody's kind of willingness to you know, feed into those you know, quite difficult and complicated discussions early on. And I think, you know, really there's a lesson for me, which is, you know, really we need to work harder to sort of build and share our kind of common understanding of the law as early as possible, and you know, really ahead of time, to be honest, because it's very, very difficult to create legal advice, you know, when new issues like this emerge, particularly given how principles-based our consumer law is, which means we tend not to have specific rules on what to do in these situations, and we have to interpret things without a lot of precedent. As cancellation, and particularly kind of travel cancellation, became the kind of key focus for us, this really did start becoming a little bit difficult, particularly on the enforcement of the package travel regulations. Now, I mean, from our perspective, trading standards are the lead enforcers for PTRs. You're the only people who've got criminal sanctions, although CMA and the sectoral regulators can enforce the PTRs via the Part 8 of the Enterprise Act. We haven't got the underlying criminal powers. And you know, to some extent, we were then, you know, trying to build our own understanding of that. Fortunately, we had some interaction with the trading standards travel law group, and you know, experts like Andrew and others in the area that we've been speaking to. So we didn't have to quite start from zero, but it has been a bit of a steep learning curve for us, because generally speaking, we use the generic horizontal consumer law, Consumer Rights Act, and the CPRs, and obviously looking at this area has not only meant we've had to sort of tread quite carefully because there are several people in the space, but also newish area of law for us, as well as that really fundamental overlap with trading standards. Obviously also overlaps with the Civil Aviation Authority on flights, with the Office of Rail and Road on railway cancellations, are they not quite such a big source of complaints? And then also kind of links with the Financial Conduct Authority's role in regulating insurance and consumer credit, because obviously two ways that people might have sought or might seek to get their money back might be to make a claim on their insurance or to make a claim under the chargeback rules or Section 75 of the Consumer Credit Act. Both both the CAA and the FCA have published various pieces of guidance about refunds. The FCA have put out something quite recently on insurance and credit act issues, which I encourage you to look at, both from a sort of personal perspective but also a professional one. Some of these landscape issues are, long overdue, at least from my personal perspective, resolution. A number of them were raised by Bays in the 2018 Consumer Green Paper, if people can remember back that far, and a lot of those are still to be implemented, and obviously there's a lot of other issues to be dealt with. But I think certainly on package travel, there's a bit of a question about who's best placed to lead. And CMA's work in the area has been a kind of very much a temporary move to deal with the fact that there were a lot of complaints and that trading standards resources were very thinly stretched, dealing with a lot of different issues. So we thought it was right to get involved, but that doesn't mean we're necessarily looking to be the lead enforcer of package travel regulations in the future. I'll skip through these. We can come back to them if people have got questions, but I mean, just some sort of very basic principles about consumer law. So obviously there's some specific law, and there's the package travel regulations I've been talking about. There's also regulation 261 on flight compensation. But even where those don't apply or they don't get you to the result you want, it's important to remember the underlying horizontal consumer law also gives you a number of rules about transparency and balance and choice, but I'll move through those. I won't dwell on those unless people want to come back to them on questions. Just briefly on the Consumer Rights Act, I mean, just to draw your attention that there's quite a lot of pre-existing material out here, and actually we did quite a bit of work on holiday cancellations, travel cancellations over the last few years, which was sort of partially helpful and partly not. Some of that work was sort of taking us in the direction of basically really saying that kind of non-refundable deposits and non-refundable bookings weren't really acceptable, that businesses needed to think about how they might offset their losses and therefore give some money back to consumers. But obviously those were written prior to this and not thinking that there might be a global pandemic that might lead to everything being cancelled. So though we've got that existing material, we obviously felt that there were some additional things that we had to say as well, which I'll come on to. I'm just doing all right for time, unbelievably. So we then decided that our existing guidance that I've just mentioned, particularly on unfair contract terms, really didn't cover some of the complexity of the current situation. And we felt that, given there were so many consumer complaints coming in, firms were sort of taking very different responses, obviously understandably quite confused about what the situation ought to lead to, who was responsible, and so we decided that it was important for us to put out a short general statement, which some of which is there, and I'll give you some of the content from it briefly, shortly, sorry. And that was published alongside an announcement of our initial 3 areas of enforcement action, which were weddings, holiday accommodation and childcare. And as I'll mention later, we then added package travel, but that wasn't actually the one of our initial areas, partly because of these landscape complexities, and that we didn't really necessarily feel it was right for us to jump into that area, given that there were others probably more familiar with the legislation, if not better resourced than ourselves. So our initial statement basically said, where the contract isn't performed, consumers should generally get some sort of refund, and that there were 3 circumstances in particular where refunds should appear, and that's where the business cancels. That's pretty straightforward. I mean, that would be the case without COVID. Similarly, with the second bullet, where there's no service provided, we would have said, well, I mean, basic contract law, you don't even really need consumer law to do that. Basic contract law says, well, if you're not given the service that you paid, you've contracted for, you should get your money back. And then the third bullet is a bit more interesting, which is where it was the government public health measures that were effectively kind of intervening between the consumer and the service, and that meant the consumer couldn't get the service. And we think the consumers really ought to get a refund in that in those circumstances as well. We obviously then provided a few more views as well, but that was our first statement, and I'll spend a bit more time on our second, which is our kind of current position. So few months went by from the end of April. We started our enforcement work on the sectors that I mentioned, and indeed also in package travel and some other informal work as well. And then as government restrictions changed, as more restrictions were added, and as those restrictions became more complicated, we felt we needed to update our statement in order to reflect those changes. So that's why we published a statement on the 28th of August. It wasn't that we had a different idea about how the law worked, it's that we had to deal with the increasing complexity of restrictions. So we reissued the statement. It was much longer because obviously the restrictions were more complicated. We had a bit more time to think about some of the issues. We'd had some interesting and useful discussions with other enforcers and indeed with businesses in the sectors that we were working at. So we reissued the statement, but with the same core that basically, where business cancels or you don't get the service, you should get your money back. And then where a consumer is prevented from receiving the services by lockdown laws, the contract is likely to be frustrated, and therefore the consumer should get their money back there. And our thinking, just to add a little bit of detail, there's obviously more in the statement itself, on that third bullet, is largely that. I mean, I guess the kind of best example would be if the consumer would have to actually, in theory, commit a criminal offence to get the goods or services, then the contract's going to be frustrated, and it's unreasonable to expect a consumer to break the law in order to uphold their contract. And I think that's kind of helpful to understand. The crucial thing we were trying to do in the second statement was to try and deal with the different legal status of some of the restrictions, and so we came up with this slightly new concept of lockdown laws, partly to deal with the fact that new rules were being added in different ways, as we continued. So we were conscious that things might have to change, more restrictions might be added as well. So we've defined what we think lockdown laws, and therefore what is covered by that third or indeed the second bullet above. And I think the really key thing here is where there is actually a legal restriction, where the isolation or the lockdown is actually mandated by law, as opposed to it just being advice, because we felt that it was harder to make those frustration arguments that we were relying on in the third bullet at the top of the page, and then the third bullet on the previous slide, where there wasn't actually a legal restriction. And where the government were just saying, well, look, you should take care, and that it was harder to make the argument that the consumer should necessarily always get a full refund there. We then obviously had to start dealing with the joy of not just UK restrictions, but potentially variable quarantines in other in travel destinations, variable quarantines on return to the UK, and that obviously complicated things further, and we've tried to be as helpful as we can there without being overly prescriptive, because of course the restrictions themselves still continue to mutate, although let's hope that the virus itself is not. So just to, I'm not going to have time to go through all these, but just to sort of give you a sense of some of the other issues. So we've got short sections in the revised statements on all of these. So we've said a little bit more about what we mean by limited exceptions to full refunds, and that's basically where the business has already spent the money and the consumers had some benefit, that probably can get some money back for that. And then I won't read out that list, but we've talked about all those future issues, and I suspect that at least one or maybe more of those is relevant to some of the thinking that you've done either professionally or indeed in your personal lives about contracts that you might have or travel services that you might want. So please do have a look at the statement. It will, I'm sure, be interesting at the least, if not hopefully a bit more useful than that. Just to give you a bit of an example, and one particularly live issue, one of the issues kind of emerging in package travel is this issue of changing foreign office advice or foreign office advice against. And this is what we've said about that. So we've said if a holiday could be cancelled in light of advice, then people should be entitled to a refund. And then we've provided some more information about that, and that gives you some of the views about this contractual frustration, which my colleague David may talk about a bit more on Thursday. But unfortunately, we would like to be able to say categorically, if FCA advice is against travel, you should get a refund under PTRs. Unfortunately, PTRs doesn't say that. And this is, a good example of the limitations of principle-based legislation, though they're great in some ways because you can use them to argue for things that you hadn't thought about, or to deal with practices that you hadn't thought about. Also, it's you have to make some of these arguments each time rather than be able to say, well, right, it's clear one way or the other. So, I mean, our current view is it seems very likely that there would be a refund, partly because of this Regulation 12(7) provision about unavoidable and extraordinary circumstances at the destination. But we're still working out exactly how hard we can push that position. There are some other interesting arguments. So, for example, you could argue that a categoric right to a refund is what people have come to expect, because that's effectively what the package travel industry have been doing for the last 10, 20 years. And therefore, reasonable expectations would mean that it wouldn't be professionally diligent under the Consumer Protection from Unfair Trading regulations to not offer a refund. So that's quite an interesting additional argument. I think there's a more pragmatic side to it, which is to be honest, if the package travel industry can't assure people that their money is protected in the event of stuff happening like COVID or other disruption, then why to be honest would people book expensive package holidays? And I think the more responsible operators within the sector kind of understand that, but obviously particularly some of the smaller operators, I think, finding it, just very difficult to actually get the money back to people. And we can perhaps come back to that in a bit. But just an interesting example and a live debate, and I suspect one that some of you are interested in personally or professionally as well. So I'll use most of the remaining time just to talk a bit about some of our enforcement work. And apologies, haven't really got, don't really have the time to talk about any of these in a lot of detail, but happy to sort of take some questions, and as I say, that have a look back at that earlier slide giving you the links to all the guidance and the published documents if you want more detail. So just have a quick canter through the 5 areas where we have taken some action. So price gouging, as I say, lots of issues, particularly at the start, some interesting conversations both about the CPR's professional diligence and aggressive practices angle, also about the potential argument for a Competition Act abuse of a dominant position, and then kind of, well, right, what regardless of what the law says, what can we do to try and get people to do the right thing regardless? We did quite a lot of work with central government, particularly the business department, on some new law which hasn't yet gone anywhere. We did open 4 Competition Act cases, all in hand sanitizer, I think, and those have all been closed since, partly because the global supply chains have been restored and so the prices aren't so high. We put some statements out and did quite a lot of advocacy work, where we work very closely with CTSI. Thank you to the policy officials and others there, and also to the other trading standards officers who've helped us feed into that, and obviously some really great work with some retail trade associations as well. And then we sent a letter out also to dissuade people from illegal price fixing as well, which is another area that the CMA works on. Just moving on to package travel, and again, apologies for sort of cantering through this. I mean, our key concern was that people weren't getting their refunds. Basically, there were some other problems. We were seeing some people charging additional cancellation fees, which we'd explicitly said in our initial and our second statement wasn't acceptable. There shouldn't be new cancellation fees appearing. Any cancellation fees would have to be fair anyway. And then another issue, which is just people trying to get through to companies and trying to get their refunds in the right amount of time. PTR specifies that you should get refunds within 14 days. Obviously, that was very challenging in practice for a lot of operators who had quite severe cash flow problems. I think some of them were having problems getting money back from the airlines as well, or still are facing that difficulty. So that remains a bit of a problem. And yeah, we had, I think it must be higher than that now, 24,000 complaints, and there was one particular company featuring prominently within that. And some of the losses were really quite high. Some of these packages, particularly the kind of more niche ones, can be extremely expensive and obviously can involve several people. And so, in some cases, there are tens of thousands of pounds being lost. But obviously, also, as well as the businesses facing cash flow problems, lots of consumers had problems too, because people had lost their jobs or faced unexpected costs themselves, and therefore may well have had good reasons for wanting them or needing the money back. So what have we done? Well, we published an open letter to the industry and wrote to over 100 firms. We hope that we've copied in the relevant local training standards department so that people are aware of what we're saying to their local businesses, because we know a lot of you been dealing with some of these issues as well. We got formal undertakings from TUI in mid-September to be clearer about refunds and to give refunds more promptly. We're obviously thinking about what else we might need to do in the sector, how we might best use our resource here, how we might best leverage effective action by consumers and other enforcers as well, because we're never going to have enough resources to deal with every individual complaint. But we think largely that industry seems to be moving in the right area, and actually to some extent the problems now seem to be more with the airlines refusing to give refunds to the package travel companies, or playing fast and loose with their Directive 261 compensation rights, although some of those aren't relevant in the pandemic. Moving on to holiday lets. So again, we had problems with people refusing refunds outright, or only offering credit notes or vouchers when people are entitled to cash refunds. Other problems about the money moving through the supply chain, so some refunds not being passed on by the property owners, and then some quite nasty practices of cancelling people's holidays, but then re-advertising them at higher prices and saying, oh well, you can rebook, but you'd have to pay more, which we thought was particularly distasteful in the circumstances. There were a few companies featuring very prominently in those complaints. Losses not quite as high as package travel, although still some quite high for some of the larger bookings. And we got formal undertakings from sites and from vacation rentals getting full refunds from consumers. So let us know if you are not getting your refunds from those companies, and we can go back to them. Obviously, still looking at complaints, but we think again, hopefully, most of the issues are resolved here. I think we've got a problem. We might have some problems with future or the current kind of pseudo lockdown and any future lockdowns and what might happen. But we've seen complaints drop away pretty steeply within the sector over the summer. Of course, that might just be because people have stopped booking holiday cottages. Weddings was another quite tricky area, and we found that lots of people were being asked for additional payments to reschedule, or not being given a refund when they couldn't hold their wedding. And there were a lot of businesses generating quite a lot of complaints, some of whom we worked closely with back in 2016. Some of you may have been involved. There was a CMA-led piece of work through the Consumer Protection Partnership to look at unfair cancellation and other terms in wedding contracts, and some of those businesses that we spoke to then still seem to be not quite getting it right. So we managed to get some commitments from Bijou Weddings to provide fairer refunds at the early part of September. And that was alongside open letters to the whole industry, some specific letters to 27 businesses where we've copied in training standards locally, and then we've also published some advice, and that's particularly because weddings create some special challenges around what costs might be recoverable or retainable. And so you end up in difficult discussions about, well, what about the cost of maintaining the lawn? How much of that is it fair to charge to consumers who might not be able to hold their wedding because of the restrictions? So suspect there will still be some issues in the sector, though we're hoping that the advice we've put out helps consumers negotiate a sensible outcome, which might be a rebooking for next year, but it might be a refund. Certainly people are entitled to a refund if they want one. And our advice, we've tried to be flexible about the numbers, so the sort of changes to reducing from 30 to 15 individuals at weddings. Hopefully our advice is proof against those changes. Just a couple more slides and then we'll have some time for questions. We also did some work on nurseries and childcare, which a lot of people were getting very unhappy about at the start, and that's partly because a number of childcare providers were either asking for parents to continue paying their fees even though they weren't getting the services, or to charge some kind of retainer fee to say, well, oh, if you don't pay this, we can't guarantee your child's place when we resume offering the services, or penalties for cancellations. Some of these were problems before COVID, to be honest, but obviously very understandable why parents didn't want to lose their kind of current place, and we had some quite serious concerns that these are probably going to be aggressive or misleading practices to be sort of trying to get money out of people where they're not getting a service at all. But we had a lot of sympathy for the businesses in the sector. Lots of them were very small. Very few of them had kind of deep pockets or kind of much access to financial backing. Lots of them were also operating some sort of service for key worker children, which kind of complicated it further. And then, who should be paying for that? Should it be the government, or should it be the parents who aren't getting the services? So some quite difficult issues, but can be very expensive, can be a lot of money for people. And obviously, if consumers were struggling to get paid themselves, you can see why they might not want to be paying their childcare fees. So we did a lot of advocacy with the sector, and really we wanted to help them get to where they wanted to be, but also wanted to be clear that they couldn't breach the law in doing it. And we've published some guidance since then, and we're hoping that most of those issues have since been resolved. And again, we sort of saw complaints drop off in the sector, having been very high at the start, but I'm sure there are still some residual issues there. But interested if any of you are dealing with any of those issues in those sectors still, and happy to try and talk about it. They will only have a short amount of time. So I guess just finally for me, just a sort of a few final thoughts. So what's happening next? Well, there might be some more enforcement action, although we've really kind of stretched our consumer capability to the limit to do those sort of 4 areas simultaneously, as well as also sort of thinking about potential work in other areas like student lets, where there's been a lot of complaints and concerns. We might be pushed to provide additional sectoral advice, although we're hoping that the materials we've put out will deal with most of the areas as in conjunction with our broader statement. Obviously, there might be new restrictions, and we'll have to hope that our existing advice is kind of robust enough to deal with those, but obviously difficult to predict. And then hopefully we're looking forward to the end of the pandemic, but obviously there's the potential for a second lockdown, and certainly at the moment feels more like we're heading in that direction. And that might mean we have to look at some of these areas again, or might need to take some tough action if people are sort of sliding away from the commitments they made earlier on. And then hopefully at some point, I guess possibly not now until next year, we might be getting back to business as usual, although how much business as usual in, say, the travel sector or other areas might be affected by this, hard to say really. Anyway, sorry to rush through all of that. I hope that's been interesting, and very happy to take some questions now if anyone has any. Grateful if people could put their hand up. I'll try and look at the chat to see if anybody is asking. Jonathan.
Oh, I'll illuminate myself. Hi, Andrew.
Hi, how are you?
Good to see you. I suppose I just wanted to know, I'm particularly pleased to see that entertainment tickets, which is my particular bag for those that don't know me, doesn't seem to feature. Is that accurate? I mean, obviously we've dealt with a lot of issues along the way, but I'm just, it seems good that it hasn't sort of featured as a major concern.
So, I mean, I guess that would fit along with, a number of other issues like or sectors like ferries or caravans into the kind of areas that we I mean, I guess to be frank, we did think about acting. But we haven't taken enforcement action in those areas, and we haven't felt it's important to provide additional guidance. I mean, I think it's probably fair to say that there are quite a lot of issues with events, festivals, gigs, I think in particular, and I'm sure those will continue because the distancing rules will make it quite hard for them to operate at normal. But yes, I mean, they didn't quite hit the same levels of complaints as some of the areas we have chosen to act on, I guess. But yeah, very happy to have another conversation about that and whether there's anything we might usefully say. Although I'd take your point about welcoming the fact that we haven't had to take enforcement action.
Well, I hope I'd hear from you if you ever felt the need to take any further. But my question really was about where there have been changes of law in Europe. So this is, again, particularly around event tickets. So where certain territories have changed laws so that promoters don't have to provide refunds for events that are rescheduled within 12 months of the original date, where that leaves UK customers in that scenario, where they've bought perhaps from a UK ticket agent who's been selling on behalf of that promoter.
That's very interesting.
Yeah.
I guess I'd have to look at the changes in a bit more detail, and maybe I should be able to comment on those off the bat. But I think I might want to look at them before commenting. But no, but that is really interesting. And
it's caused us some sort of head scratching, I think, because those laws have been changed for good reasons to protect those promoters for those events. But whether that has an impact on UK customers. But I realise that it's a very specific question.
Fair enough. No, I mean, you're talking about changes within specific member states rather than at an EU level.
Yes.
Yeah. Okay. I mean, it'd be really interesting to have a separate conversation about that.
Okay. All right. I'll send you an email. All right.
Thanks, Jonathan. And good to see you.
Good to see you. Yeah.
Any other questions or comments? So I guess my colleague David Perry is giving a presentation on Thursday, which will look at the sort of more of the legal detail around cancellation, and so perhaps give you a chance to dig deeper into any of those queries around the 1943 Frustration Act, for example, or how unfair terms relates to frustration. I'm sure David will be delighted to try and answer those questions, but happy to discuss any of those now, or indeed if there are particular questions you want to ask him, then let me know now and he can perhaps prepare his answers to those. But happy to talk about any of those sectors in more detail, or indeed sectors I haven't covered, like ticketed events. I can't see any more hands. I'm just going to check the chat to see if there's any questions anyone's put in there. Doesn't look like it. So I'm sure you're now all fully capable of going away and taking enforcement action or creating fair contracts, depending on which side of the fence you're on in relation to COVID. I'm sure that's sounds like that's all clear. Okay, well, if people do have questions or comments arising out of that they don't want to raise in public, or they only occur to them later, then do drop me an email. It's andrew.hadley, all lowercase, at cma.gov.uk if you want to contact me. And I hope you've found the session useful, and I hope you enjoy the rest of the symposium. Thanks very much for listening.